We have a roll call vote expected soon, but I wanted to get this started, and then we can, when the vote occurs at some point, we can recess for a few minutes while we go and vote. But what's important about this hearing, we're going to hear from the President's Review Group on Intelligence and Communications Technologies. I was talking briefly with them in the back, and I know this is the first time they've appeared together publicly since their groundbreaking report was released last month, and I thank them, as I know the President has and others have, for taking the time, a lot of time and effort, to prepare this report. And I know it will be reflected in what the President's going to say later this week. The review group's report addresses some of the weightiest issues that are going to confront us in the coming years. We know what the technology is today. None of us can predict what it's going to be 5 to 10 years from now. And we also know that more and more data will be created by all of us as each day passes. And the questions are obvious. When should our government be allowed to collect and use that data? To what extent does the massive collection of data improve our national security? And what will the answer to these questions mean for privacy and free expression in the 21st century? And all three branches of government are grappling with whether to let the NSA's dragnet collection of Americans' domestic phone records to continue. And we're finally doing so with full public participation in that debate. I think Americans across the political spectrum want us to have this debate and want to have a clear understanding of what is going. So we're trying to get as much as we can into a public hearing. All of us on this committee have had access, as have the 5 witnesses, to highly classified matters, but we're trying to go into as much as we can in open session. And the most critical factor in deciding whether to conduct any particular intelligence activity is an assessment of its value. This is particularly important in evaluating the phone records program conducted under Section 215 of the USA Patriot Act. As I've said repeatedly, I've concluded this phone record program is not uniquely valuable enough to justify a massive intrusion on Americans' privacy. And the review group likewise concluded the program has not been essential, saying, and I'll quote the review group, "The information contributed to terrorist investigations by the use of Section 215 telephony metadata was not essential to preventing attacks and could readily have been obtained in a timely manner using conventional Section 215 orders." And then even a few pages later, they said Section 215 has generated relevant information in only a small number of cases, and there has been no instance in which NSA could say with confidence that the outcome would have been different without the Section 215 telephony metadata program. And the report explains that nothing in Section 215, as interpreted by the FISA court, would preclude the mass collection of Americans' personal information beyond phone records. And the privacy implications of this sort of massive surveillance in the digital age can't be overstated. And the review group's report provides some very valuable insights. The report appropriately questions whether we can continue to draw a rational line between metadata and content. And I think that's a critically important question, given that many of our surveillance laws depend upon the distinction between the two. These insights are also important as we take up reforms to the national security letter statutes. We don't talk as much about the national security letters, but using them, the FBI can obtain detailed information about individuals' communication records and financial transactions and credit reports. Do that without judicial approval, but the thing that is troubling to many is the recipients of NSLs are subject to permanent gag orders. Now, Senator Durbin and I have been fighting to impose additional safeguards on this controversial authority for years, to limit their use, to ensure that NSL gag orders comply with the First Amendment, and to provide recipients of NSLs with a meaningful opportunity for judicial review. something that most Americans would assume already exists. And the review group makes a series of important recommendations to change the way national security letters operate. We haven't seen as much about these recommendations in the press. They haven't generated as much attention, but they should. And I think that we have to look at it. And then the report also recommends creating an institutional public interest advocate at the FISA court. I strongly support that proposal. I am concerned that merely allowing for the amicus to participate at the FISA court from time to time will neither improve the substantive outcome of the proceedings nor rebuild public confidence in the process. And the stakes are high. When you think about it, we're really having a debate about what are Americans' fundamental relationship with their own government. The government exists for Americans, not the other way around. And about whether the government should have the power to create massive databases of information about its citizens. And this is a feeling I'd have no matter who is the head of our government. I believe strongly that we must impose stronger limits on government surveillance powers. I'm confident that most Vermonters agree with me. I believe most Americans agree with me. Having said that, we want to do it right. Now, in our panel today, we'll have Richard Clark, who is the CEO of Good Harbor Security Risk Management. He's chairman of the Board of Governors of the Middle East Institute. During his 30 years of public service, he was a senior White House National Security Advisor to Presidents George H.W. Bush, where I first met him, Bill Clinton, and George W. Bush. Then we'll have Michael Morrell, who recently retired as the Deputy Director of the Central Intelligence Agency after more than 30 years of service, and during that time, he served as acting director. He earned his bachelor's degree from the University of Akron and a master's degree from Georgetown. And Jeffrey Stone currently serves as a professor at the University of Chicago Law School, previously clerk for Supreme Court Justice William Brennan. And Professor Stone has also served as dean of the University of Chicago Law School and the provost of the university. Cass Sunstein is currently a professor at Harvard Law School, previously served as administrator of the Office of Information and Regulatory Affairs. He also served as attorney advisor at the Office of Legal Counsel of the Department of Justice and was a law clerk to Supreme Court Justice Thurgood Marshall. And last, Professor Peter Schweier is currently a professor at the Georgia Institute of Technology, previously taught at Ohio State University's Moritz College of Law. 2012, he was named to co-chair the Do Not Track Standards process of the World Wide Web Consortium. He served as the Clinton administration's chief counselor for privacy from 1999 to 2001. Now, gentlemen, did you have a particular way you wish to proceed?
Well, after consultation with your staff, we have a very brief opening statement, if that's agreeable to you, Mr. Chairman. Notwithstanding our diversity, which you just signaled, we began this process with great admiration and gratitude for the intelligence community. And we'd like to start by honoring their extraordinary work in keeping the nation safe. The risks associated with terrorism and associated threats are real, and one of our main goals has been to suggest reforms that are compatible with combating those risks. After extensive discussions and consultations during the last months, the gratitude and admiration that we had for the intelligence community has only increased as a result of interacting with them. We found the highest levels of professionalism. We found no evidence of political or religious targeting or targeting because of political dissent. Their focus has genuinely been on national security. We are also grateful to them for their help and cooperation on a very tight time schedule, and they provided us with great access to information, making our report possible. We're also grateful to many organizations and individuals, over 24, in fact, who actually met with us, concerned with technology and innovation, with privacy, with civil liberties, with freedom of the press, with the rights of journalists, with our relations with other nations, friendly nations and some that aren't particularly friendly, but ensuring that our relations are as cooperative as possible. Countless organizations and individuals have devoted energy and time to informing our work, and we are grateful to them. Much of our focus has been on maintaining the ability of the intelligence community to do what it needs to do. And we emphasize, if there's one thing to emphasize, it's this, that not one of the 46 recommendations in our report would, in our view, compromise or jeopardize that ability in any way. On the contrary, many of the recommendations would strengthen that ability explicitly by increasing safeguards against insider threats and by eliminating certain gaps in the law that make it hard to track people under circumstances in which we have reason to believe they don't wish to do us well. In terms of the reforms we favor, just three very general points. The first is the immense importance of maintaining a free and open internet, promoting both democratic and economic values. Across partisan lines, there's a commitment to internet freedom, and what's done in this domain, we believe, should be compatible with that commitment. The second is the importance of risk management, signaled, I think, Mr. Chairman, by your opening remarks. That's a central unifying theme. Considering multiple risks, first and foremost, the risk to national security, but including also the risk to public trust, risk to privacy, risk to economic values, and risk to democratic self-governance. So a major task going forward, what our report tries to thread a needle on, is to try to ensure a full set of risks are taken into account and that we aren't optimizing only along one dimension. The third point is the importance of accountability, which is a unifying theme for our 46 recommendations. Accountability to senior level policy officials, accountability to the legal system, to Congress and this committee through increased transparency and disclosure, and above all to the American people through transparency and disclosure. And I should emphasize that one form of accountability includes steps that would help increase public trust, not just within the United States, but throughout the world. This is a diverse group, as noted. We reached all of our recommendations, and this is a bit of an upset, by agreement. There are no dissents, there was no horse trading, and there was no compromising. There are 46...
You'd never make it in the Senate.
There are 46 recommendations. If my arithmetic is right, we have 230 votes. That is, all 5 of us are behind all 46 recommendations. No team bats 1,000 or even comes close, and our transmittal letter makes clear to the intelligence community, to this committee, to the American people, that we offer our recommendations with a great deal of humility and as a mere part of a process, prominently including the deliberations and judgments of this committee. We look forward to your questions.
Thank you very much. And I, notwithstanding the comment I made, I think a couple of things are extraordinary here. One, that you did reach such consensus, and I wish we could reach the same kind of consensus in the Senate. And many things we do, but not enough. And secondly, your comments about the professionalism of our intelligence, the men and women in our various intelligence communities, I totally agree with you. As Mr. Morrell knows, without going into the subject of some of our closed-door briefings, he has heard both Republicans and Democrats praise the work and some of the things he's had to bring before us on some very critical matters. And I have spent enough time with stations chiefs around the world in different places and realize how important the work that they all do. Now, when the bulk phone records program was made public last year, There were some who immediately began arguing the program was critical to national security. They cited 54 terrorist plots been thwarted. Now, you've had the reason to review those 54 examples as I have. So I read the report, it reaches the same conclusion that I and others here did, that the Section 215 program contributed to only a few of those cases, was not essential to preventing any terrorist attacks. So that has been put to record. I think it's also important to look at another thing we keep hearing, that somehow if this program had been in place before 9/11, it could have prevented that. Now, Mr. Clark, you were a senior counterterrorism official at the time of those attacks. Would the bulk phone records program have prevented 9/11?
Senator, I think it's impossible to go back and reconstruct history. And I think while what if history is interesting academically, it's very difficult to say with accuracy if one fact had been changed, if the outcome would have been significantly different. I think we can say this, that if the information that the federal agencies had at the time had been shared among the agencies, then one of them, the FBI, could have gone to the FISA court and could have, in a very timely manner, gotten a warrant to monitor the appropriate telephones. They didn't because they were unaware of the information that existed elsewhere in the government at the time. But there was a period of over 2 years where that information was available. So it would have been possible in a very timely manner to get a warrant from the FISA court.
Wasn't that one of the things that the Senator Graham and his review committee found, that it was a sharing?
That's exactly right. The Joint Committee, the two intelligence committees of the House and Senate, found that the information was in the government at the time, it just wasn't shared.
Now, I raised the issue of national security letters, or NSLs. And as you know, that, and for those who are not familiar, they permit the government to obtain certain communications and financial and credit report records without a court order. Also, as I raised, the FBI can impose a virtually permanent gag order on NSL recipients. A number of us have been trying to reform that. Your recommendations on NSLs haven't had as much attention as other topics covered by the report, but I think they're just as important. And so, Professor Swire, how did the review group arrive at its conclusions regarding NSLs?
Thank you, Mr. Chairman. Well, we arrived at it, the group amongst us includes 3 law professors, so on legal matters we were particularly involved. We went to the FBI and we interviewed FBI counsel in detail. We also, amongst us, had worked quite a bit on issues related to NSLs previously. Based on that, one of the things we focused on was the so-called gag orders or non-disclosure orders. In the criminal world, when there's an organized crime investigation, there's often non-disclosure orders on the order of 45 or 60 days. We found out that they're either permanent or come up for review for the first time in 50 years under current law for NSLs. And that's very, very different from the way that grand jury subpoenas or investigations on the criminal side happen. And so that lack of disclosure and the long, long period of secrecy is certainly one thing we were concerned about.
Well, and doesn't that create a real problem in some cases, the person receiving this NSL, the gag order?
Well, so it poses problems for the email providers, phone companies who receive the NSLs, where they're not in a position to describe what activities they're taking. That can lead to situations where, among other things, that the actual facts might be quite reasonable if understood more broadly. Many of the providers have expressed concern that they, under this gag order, cannot reassure their customers about the good practices that exist, and that's been a concern for the industry, certainly.
Well, let me, before I yield to Senator Grassley, Professor Sunstein, let me ask you, some would say the NSLs are like grand jury subpoena. And you can have the gag orders, not judicial review and so on. Do you agree with that?
There is an overlap, and the FBI has been driving that analogy. There's also another analogy, which is Section 215 itself, where we recommend a certain process that's more consistent with the normal one for getting access to people's records. We think that if 215 has the structure that it should, then the national security letter should follow the same structure, that the separation between them is extremely hard to justify. There is a certain analogy to the administrative subpoena. There's a question of breadth and scope with respect to national security letters, and we think that given the emergency exception that of course there would be, that to treat the national security letter like a 215 record seeking would not compromise any national security goal.
Thank you, and thanks, Senator Grassley, for letting me through. Just one more question. I'll say this to Mr. Morrell. We've heard some government officials talk about Section 215 programs. They say Americans shouldn't be concerned about them because the phone records the NSA obtains are just metadata and not particularly sensitive. The review group said there were some risks imposed by the government obtaining massive amounts of metadata. Could you just elaborate on that a little bit?
Well, I'll say one of the things that I learned in this process, that I came to realize in this process, Mr. Chairman, is that there is quite a bit of content in metadata. I mean, when you have the records of the phone calls that a particular individual made, you can learn an awful lot about that person. And that's one of the things that struck me. So there's not, in my mind, a sharp distinction between metadata and content. It's more of a continuum.
Well, in fact, in the New York Times op-ed, the 5-year wrote, the government should end its domestic program for storing bulk telephone metadata. Current program creates potential risk to public trust, personal privacy, and civil liberty. And of course, the concern I've had and some others have had, no matter who is president or who's the head of these agencies, we don't want the temptation in there to misuse it. But Senator Grassley, thank you for coming over. And I note that senators have been joining us. I think we were all told there's going to be a vote at 2:30, and apparently that has not happened. And if we keep looking over your head, we're looking at those little white dots up on the clock to see when the next one might be. Senator Grassley, go ahead.
The chairman just explained what I wanted to explain, that you folks may not think this is a very important hearing, but it is a very important hearing, but you may not conclude that since other members aren't here, but we were all told that there was going to be a vote at 2:30. Before I ask questions, I have an opportunity to give an opening statement. I thank all of you for being here and for your work on the committee. This is the latest in a series of hearings on government surveillance that our committee has held. The NSA continues to be of great concern to my constituents and many across the country. The most important responsibility of government is to protect our national security while at the same time preserving our civil liberties. This is a responsibility that's quite hard to meet. Rapid changes in technology are making our enemies more lethal, our world more interconnected, and our privacy more subject to possible intrusion. Under these circumstances, it's useful to hear a variety of perspectives, including from those outside the government. And I thank the members of the review group for your service. Some of the conclusions in the review group's report may help clarify the issues before us as we consider possible reforms. First, according to the report, quote, although recent disclosures and commentaries have created the impression in some quarters that the NSA surveillance is indiscriminate and pervasive across the globe, that's not the case, end of quote. Then the report, I quote again, concludes, quote, we have not uncovered any official efforts to suppress dissent or any intent to intrude into people's private lives without legal justification, end quote. None of this means that the potential of abuse of these authorities shouldn't concern us. It should. Or that the NSA hasn't made serious mistakes, or that the law in this area couldn't be improved. Indeed, there's a place for additional transparency, safeguards, oversight, but these conclusions are helpful in clarifying the issues. Second, the report recommends that, quote, the national security of the United States depends upon continued capacity of NSA and other agencies to collect essential information. In considering proposals for reform now and for the future, policymakers should avoid the risk of overreaction and taking care in making changes that could undermine capability of the intelligence community, end quote. And that's very good advice, folks. One recommendation that may reflect this advice is a review group's proposal to preserve the government's controversial ability to query telephone metadata, but with some changes. One of those recommended changes is that private entities hold the metadata. This is an interesting idea, perhaps worth investigating, but I think it's legitimate to have concern that it may create as many privacy problems as it solves. Indeed, private companies seem to be allowing their customers' information to be hacked on what seems to be a daily basis. Just as importantly, I'm concerned that in other instances, a review group may not have followed its own advice. Some of its other recommendations may seriously threaten our national security if adopted collectively. Example, some of the recommendations in the report appear to make it more difficult to investigate a terrorist than a common criminal. Some appear to extend the rights of Americans to foreigners without good reason. And some appear to rebuild the wall between our law enforcement and national security communities that exist before September 11th, 2001. Of course, that wall helped contribute to our inability to detect and thwart the attacks on that day, and thousands died as a result. I don't mean to criticize the effort or intentions of a review group, but I'm concerned that the group was giving such a relative short time to do their work. As a result, for example, I understand the group spent only one day at the NSA, and if I'm wrong on that, you can correct that. I'm also concerned that the group lacks some important perspectives. For example, none of the members has experience in supervising terrorism investigations at the Department of Justice or the FBI, and concerned that the group produced a large number of recommendations but didn't develop some of them fully. As the review group wrote, its recommendations, quote, will require careful assessment by a wide range of relevant officials with close reference to the likely consequences, end quote. That's pretty good advice, and I look forward to beginning that process today. Now I have a question for Dr. Morrell. After the review group issued its report, you wrote an opinion piece in which you emphasize that the report recommends changing the telephony metadata program rather than ending it. You wrote that had the program been in place more than a decade ago, it would likely have prevented the September 11th terror attacks, end of quote. Further, you wrote that the program has, quote, has the potential to prevent the next 9/11. So question, I'd like to have you expand upon why you hold those two opinions, and also, can you give us any specific examples of how metadata program was valuable to you when you headed CIA?
Press the button.
Senator, let me first say that the reason I wrote the op-ed, particularly with regard to 215, is I felt that there was a misperception on the part of the media and much of the American public that the review group had indeed recommended an end to the program, and we did not do that. We recommended a change in approach, and that was the main reason I wrote the op-ed, is to make that clear. It is absolutely true that the 215 program has not played a significant role in disrupting any terrorist attacks to this point. That is a different statement than saying the program is not important. The program, as I said in the op-ed, only has to be successful once to be invaluable. And it does carry the potential going forward to prevent a catastrophic attack on the United States. And that was another point I was trying to make, and I believe it. Another point I'll make, Mr. Chairman, is that, and we talked about this as a group, there is value in a negative query of the 215 data. So if you have a terrorist overseas who is talking about an attack and you don't know where that attack is going to be, it is invaluable to query the 215 database. And if the answer is that terrorist doesn't have any contacts in the United States, that gives you some reassurance that the attack will not be here. We talk about that in the report, and I think that's another important point.
Thank you. For anyone, I have a question, but let me read a lead-in. One of the changes that your report recommends concerning the telephony metadata program is that a private third party or parties hold the metadata instead of the NSA. But we've seen many recent instances where companies like Target and Neiman Marcus have been unable to protect private data. My constituents would be very concerned about privacy issues. So any one of you, but hopefully not all of you, because I want to ask one more question. What was the group's assessment of the privacy risks associated with your recommendation that the metadata be stored in private hands? And did you speak to the telephone companies to explore whether they are willing or able to hold the metadata?
We did speak with the telephone companies about that, and they obviously would rather not hold that data. Our judgment about the government holding the data is that the primary danger of the 215 telephony metadata program is not if it is used only in the way in which its use is authorized, but that it leaves sitting out there a huge amount of information, personal information about Americans that could be abused in awful ways. And the question is how to avoid that potential abuse. And one of the ways we decided it makes sense to avoid that is to take it out of the hands of government. The concern of the Fourth Amendment, the concern of our constitutional history, is that government can do far more harm if it abuses information in its possession than private entities can. And therefore, our judgment was that the government should not have possession of this information, because if it does, there's always the possibility of someone coming along down the road, seeing this as a great opportunity to get political dirt on individuals, on their activities, on their organizations, their associations, and that's a danger that we want to avoid. On the other hand, we do believe that the data is useful, and the idea was to find a way that would enable the government to have access to the data, but minimize the risk that it could be abused in that way. And our judgment was that keeping it in private hands would still pose, as you say, privacy risks, but the privacy risks would be of a very different order, and they would be much less in the sense of the kind of abuse that historically we're most concerned about with the government.
This will be my last question. One of the things that I'm concerned about is that we not rebuild the wall that exists between our law enforcement, national security communities before September the 11th. Part of that is making sure that we don't make it harder to investigate a terrorism case than any other type of crime. FBI Director Comey weighed in last week on reforms you proposed to national security. He called these letters quote, a very important tool that is essential, end of quote, to the work of the FBI. He also stated, quote, what worries me about the suggestion that we impose a judicial process on NSLs is that it would actually make it harder for us to do national security investigations than bank fraud investigations. Question to Professor Swire. I think maybe somebody else more appropriate, but whoever.
Well,
why would we want to make it harder for agents and prosecutors to invest espionage and terrorism than other crimes? Did you consult with Director Comey personally about these recommendations? And finally, aren't your recommendations in this area almost exactly the same as what you, I assume, Professor Swire, recommended to this committee back in 2007, long before the recent controversy about NSA?
Well, law professors are always thrilled if someone reads their articles from several years ago. So it is true that I wrote on FISA prior to that, It's also true that we went to the FBI, that the FBI lawyers came to us, and that we met with Mr. Comey last week to discuss these issues. So we've had quite extensive discussions. In terms of the comparisons with any criminal investigation, of course, you have all the criminal powers, and then you may also have the NSL and foreign intelligence authorities. There are some differences. One difference is that in the criminal investigations, if there was some mistake or problem, that comes to light, and there's a check and balance there. If you have 50 years of secrecy, we never find out what the government's doing. And so because of that risk of long-running secrecy and not knowing what it is, some extra safeguards are appropriate for these secret foreign intelligence things. That's at least one difference that exists.
Okay.
Thank you.
Go ahead. No, oh, you done? No, I'm done.
Okay. I'm going to yield to the chair of the Senate Intelligence Committee, Senator Feinstein. Before I do that, I just want to place in the record, and I meant to have done this earlier, a detailed report published by the New America Foundation concludes the executive branch claims about the effectiveness of Section 215 phone records are overblown, even misleading. And then a new report by a Hoover Institution researcher concluding that Section 215 phone records is only of marginal value. Without objection, those will be placed in the record. And again, I want to say how much we appreciate the Senator Feinstein as a member of this committee with her expertise, and the other members who also serve on the Intelligence Committee in both parties. Senator Feinstein.
Well, thank you very much, Mr. Chairman. I appreciate those comments. I'd like to submit a statement for the record, if I may.
Can I at the same time ask for something to be put in the record?
Absolutely.
Without objection, the items by both Senator Feinstein and Senator Grassman made part of the record.
Thank you very much, Mr. Chairman. Mr. Chairman, the Intelligence Committee, and I think virtually every member was there, perhaps missing one, had the opportunity of talking to the professorial element of this committee last week. The intelligence element wasn't there, and we very much regret that Mr. Clark and Mr. Morrell were not there. But Mr. Morrell, particularly for your ears, I think what we thought in reading the report and in listening to the testimony was that the group didn't want the program to continue. And then I read your op-ed piece in the Wall Street Journal, in the Washington Post, and I'd just like to read parts of it and see if the committee agrees, if I may. Several news outlets have reported that the review group has called for an end to the program, but we did not do that. We called for a change in approach rather than a wholesale rejection. To better protect the privacy and civil liberties of Americans, key values of our republic, we recommended that the government no longer hold the data and that it be required to obtain an individual court order, which I want to ask you about, for each search. But make no mistake, the review group reaffirmed that the program should remain a tool of our government in the fight against terrorism. Then you go on. Another misperception involved is the review group's view of the efficacy of Section 215. Many commentators have said it found no value in the program. The report accurately said that the program has not been essential, and I want to also talk about the word essential, to preventing attacks since its creation. But that's not the same thing as saying the program is not important to national security, which is why we did not recommend its elimination. Mr. Swire, do you agree with that? Yes or no?
There were about 14 things there. I'm sorry, Senator, but I was trying to write them down. Yes, on going to the private sector and keeping the program. Yes, on the court order for each search. And the last part was not that it's useful to have the information from the program, roughly speaking.
Yes.
Yeah, I agree with that also.
Security. Yes. Okay. Mr. Sunstein?
I agree with every word.
Professor Stone?
I agree. I think it's important to understand what value is. Value is not demonstrable from specific cases that have arisen in the past that suggest that but for 215 we would not have been able to support any particular terrorist attack. The value, we believe, is primarily that it is possible that in the future there will be an instance in which 215, if it exists, will enable us to prevent a major attack which otherwise we could not prevent. Our judgment was it does have value in that way.
Thank you. Mr. Clark, welcome. It's good to see you again. Yes or no?
Senator, I think we are surprisingly all in agreement.
Good. That's what I wanted to know. Thank you very much. Now the word essential. This is a word that's debated as to its meaning. We have one recent court decision out of the Southern District of New York, and I'd like to read from page 48 of that opinion. The effectiveness of bulk telephony metadata collection cannot be seriously disputed. Offering examples is a dangerous stratagem for the government because it discloses means and methods of intelligence gathering. Such disclosures can only educate America's enemies. Nevertheless, the government has acknowledged several successes in congressional testimony and in declarations that are part of the record in this case. In this court's view, they offer ample justification. And then it goes into Al-Qaeda-associated terrorists in Pakistan, connected with an unknown person in the United States, the Nazibullah Zazi case, and particularly where 215, according to the court, came in, was that NSA was able to provide a previously unknown number of one of the co-conspirators, Adas Metajunan. The next one is January of 2009, an extremist in Yemen, connection with Khalid Ozani in Texas. NSA notified the FBI, which discovered a nascent plot to attack the New York Stock Exchange. Using a 215 order, NSA queried telephony metadata to identify potential connections. 3 defendants were convicted of terrorism offenses. And the fourth, again, this is a court opinion, in October 2009, while monitoring an Al-Qaeda-affected terrorist, the NSA discovered David Headley, who is a major figure, was working on a plot to bomb a Danish newspaper office that had published cartoons depicting the Prophet Muhammad, and it goes on from there. So the word essential, I think, is a word that is often debated. You also say that it was likely that with al-Midhar, this could have prevented 9/11, and it could quite possibly prevent another 9/11. Am I correct about that? Mr. Murrell?
We, as a group, ma'am, did not.
No, I'm asking what you said in the op-ed.
Yes, I said that.
Okay.
But we never talked about that as a group, about 9/11. We never came to a judgment about that as a group.
It was just your opinion.
That was my opinion.
Now, let me ask you another. General Alexander testified to us that in 2009, the NSA did, in fact, go to the FISA court and found that it took 9 days, average, to be able to collect the information that was necessary. Are you aware of that?
No, ma'am.
Well, that's according to testimony by General Alexander. We also know, my time is up. Is that what you're saying to me?
Yes, go ahead and finish your
Would
question.
you just let me finish?
Of course.
I really appreciate, thank you. He can be very strict. This was used after the fact in the Boston bombing. But here's the difference. They used emergency powers, and they were able to get information quickly. This is used to prevent an attack. So those of us that see it important to prevent another attack, I don't need to tell you, terrorism is up, groups have metastasized, we know they'll come after us if they can. There's a real litany here of fact. So the question comes, do you not find value, substantial value, in being able to prevent this attack?
So I find substantial value in any tool that helps us prevent attacks. I believe that 215 carries the potential to prevent attacks, and that's why I think it needs to continue. But one of the important issues, I think, is the question of efficacy for us did not really impact our view on the change in approach to the program. We do not believe that we're going to add a substantial burden to the government by making the changes we are suggesting. If something can't be done quicker than 9 days, then they need to make some changes to make that happen. We also wrote into our report an emergency provision so that in an emergency situation, when the intelligence community knows they need to move quickly, they'll be able to query the data without a court order, going to the court after the fact.
Thank you very much.
And I should note, you weren't here for this part of the testimony, the talk about 9/11, that one of the biggest problems there is that we had the information that would have prevented 9/11,
Didn't
but
communicate it, yeah.
the people with it did not communicate as they should have. And I recall some of the information we had finally being translated a week or two after the event. Senator Lee.
I'm told that my distinguished colleague from South Carolina, a senior to me, needs to go somewhere. So in deference to the gentleman from South Carolina, I'm going to let him go first.
You really want to give him that much deference?
Well, he's been nice.
Can we vote on it?
I've always liked Utah.
Senator
and think Air
Graham.
Force Base should be bigger. Okay.
Senator Graham,
so,
please.
thank you.
Please go next, and just so we'll know, we'll then go to Senator Blumenthal, then back to Senator Lee, then back to Senator Frank, and then to Senator Cruz. Senator Graham.
Let's pick up on what the chairman said. You wrote an op-ed.
Turn your microphone on.
Okay, there we go. Michael, you wrote an op-ed piece opining that you think that this technology, if it had been in place before 9/11, could have helped prevent the attack. That's your personal opinion.
Yes, sir.
How many people agree with that? Raise your hand if you do.
I'd say, Senator, that
That's not raising your hand.
I think the reason we're not raising our hand is not that we disagree with
Okay.
Michael Morrell, but that we are not specialists in the details of 9/11.
Fair enough.
We didn't investigate.
Fair
that.
enough.
They
Fair
did
enough.
when I read
That's
it.
fair.
They just said they did when I read it to them.
Well, we'll just go with what you said.
We agreed with the quotation Senator Feinstein read from Mr. Morrell's Washington Post op-ed. On the 9/11 issue in particular, we did not discuss that as a group.
Okay. Well, we'll take what she said. They agreed with you. That's good. Bottom line is, let's get way at the 30,000-foot level. What are we trying to do? Do you believe as a group we're at war with radical Islam?
I do.
How many of you believe we're at war? Okay. The difference between fighting a crime and a war, there's fundamental differences. Do you agree with that? Intelligence gathering is a very important tool in fighting a war. Do you all agree with that?
That's a
Prevention
principal
is
theme.
important
That's a
as
theme of
crime.
our report.
Yeah, so I guess what I'm trying to let the nation know that what y'all gentlemen are trying to do is we're trying to find a way to fight a war within our values, and this is an unusual situation. There's no capital to conquer. There's no Navy to sink. There's no Air Force to shoot down. We're fighting an ideology. And if we all believe that the enemy doesn't mind dying, matter of fact, that's first prize for these guys is to die, we got to hit them before they hit us. Is that generally the thought process here? We got to identify the attack before it happens. They will not be deterred by death.
That sounds fair,
Okay.
and some version of that's in our report.
Okay, fair enough. Now, Anwar al-Awlaki, he's deceased, but he was an American citizen in Yemen. How did we miss the fact that a major in the United States Army was communicating with him? I mean, we got all these programs, and everybody's wanting to revisit these programs, which I totally understand. But we've got a major in the United States Army that wound up killing 19 people, I think, that was openly talking for the whole world to see to one of the chief terrorist suspects in the world in Yemen. How did we miss that, and what can we do to make sure we don't miss that in the future?
I don't quite understand, to be honest, the thrust of the question. I mean, our recommendations do not take away the ability of the government to use the bulk telephony metadata program. We shift where it stays, whether that is from the government to private sources. We say a court order should be necessary, but as we make very clear in the report, we do believe it's critical to protect the national security of the United States. And we believe that our recommendations are consistent.
The fact that nobody can answer the question, I understand reforming the program and trying to be more sensitive to privacy concerns, but no one's really talked much about the fact that you had a major in the United States Army on active duty, openly communicating with a known terrorist, following his every word, and eventually got radicalized and killed 19
Senator, so we do have a section in the report about military and war that talks about how the same internet, the same hardware, the same software that's used in Afghanistan and Iraq, these days are used back home. And so when it comes to the surveillance on hardware and software over there, it's the same hardware and software here. And that didn't used to be true nearly the same extent in previous wars. So how we build an internet at home and an internet for war fighting is a challenge we talk about in the report.
Let's just use the Anwar analogy. If he is calling someone, we got a cell phone, and he's dialing someone into the United States, calling someone, the program after the changes you're recommending, can it still pick that up?
Yes.
Yes.
Okay. Would a court order be necessary?
Unless there was an emergency, yes.
Well, do you agree with me that you don't need a court order to surveil the enemy in a time of war?
Overseas, yes.
Yes.
Not in the United States.
So
Okay, do you agree with me he would be an enemy combatant? That he would fit the definition of an enemy combatant?
we'd probably want to look at that, the legal authorities on that. I don't think we disagree with it.
Well, the main
we don't have
point
a
is
legal
that
view.
you believe we can still pick up that phone call.
Okay, well, we distinct, yes, we
Okay,
distinct.
that's all I wanted. That's good. Now, if somebody is calling him from the United States, can we pick up that phone call and do something about it?
If either ends overseas, it's not 215 that's an issue. It's 702 or the
Most
executive
Americans
order.
could care less about the titles. They just want to know
But,
if somebody
but it's
in the
relevant to
United
our recommendation, sir, because on 702, which is the one side is overseas, we keep the same structure basically it has today. And we're
Okay,
not,
so can you reassure America that if somebody in the United States is calling a known terrorist in Yemen, we can pick that up and do something about it?
Yes.
And at the end of the day, my time is up. Isn't that what we're trying to do? Aren't we trying to find out who's talking to who when the person, one of the people doing the talking is somebody we're really worried about attacking the nation, and we're really not trying to do anything more than that?
Yes, Senator, and I think that's a very important point because it applies both domestically, where there are concerns about monitoring of American citizens that don't fit our aims, and also internationally, where our focus is on the sorts of situations you're discussing and not on picking up people's private communications.
Thank you all for the service to our country.
And I appreciate you knowing the difference between the 702 and the 15, of course. And I would say to my friend Senator Graham, we ought to look at what are adequate safeguards, especially when we're dealing with an agency that didn't have adequate enough safeguards to keep a subcontractor from stealing millions and millions and millions of files, and they still are today, after spending millions of dollars, don't know all that he did steal. And that, I just don't want to get lured by all the technology we have, lured into complacency. We saw the same thing, and I don't mean to be picking just the NSA, when the State Department, the military put all kinds of files and all where a private first class could go in and download it all on a Lady Gaga CD, and then caused, as we all know, enormous difficulties for the United States when these very highly classified cables from our ambassadors were made public. Senator Blumenthal.
Thank you, Mr. Chairman. Thank you for holding this hearing. Thank you to each of you for your very impressive and extraordinarily important work. I think you have elevated and provided credibility to very specific and very significant proposal that advance the reform effort in our intelligence gathering operations. And Senator Graham referred to the present effort to counter terrorism as a war. There is a saying, it's an adage, I believe it's attributed to the Romans. My classic education isn't good enough to know, but the saying is, in war, law is the first casualty. And you have provided a really profoundly important service in making sure that we do not have law as the casualty. And as you say in your report, it's the first principle you state: the United States government must protect at once two different forms of security: national security and personal privacy. And there's a reason why courts matter, why the founders of our nation thought they mattered. They wanted to prevent general warrants and secret courts, like the Star Chamber. And it was one of the reasons they rebelled against it. And so my questions focus on the courts. And I've advanced and proposed the constitutional advocate, the public interest advocate, however you want to label it, that would be independent, institutionalized, to assure that there is an adversarial proceeding whenever the advocate thought it was necessary, not on an ad hoc basis, not when the court thought it might be useful. But courts benefit from hearing both sides and from having the advocate decide that another side should be represented. And I'd like to hear from you, because we've heard the contrary point of view, that it should be an amicus brief, as it has been sometimes called, or some other kind of ad hoc proceeding. And maybe beginning, Professor Sunstein, with you, stating on behalf of the panel why you chose this structure, because obviously the President is going to have to make a decision as to whether to adopt that idea, and we as a panel and the Senate will have to deliberate as well.
Well, history is relevant here. So there was an understanding when the court was created that it would be basically dealing with issues of fact, like whether a warrant was justified, not with large issues of law and policy. And as the system has developed over the years, as you're well aware, Senator, often the judges are being asked to decide those large questions. And so an adversary proceeding seems warranted in a setting of that kind. We're well aware that some judges, for whom we have a lot of admiration on the court, believe that the judge ought to be in charge of deciding when the public interest advocate is relevant. We think that's not consistent with our traditions. Normally, it isn't the case that the judge gets to decide. This interest gets a lawyer. So we think to have someone who's a dedicated officer designed to protect privacy and liberty interests is a very important safeguard.
And the provision of an adversarial proceeding, such as you've described, which reflects the change in the role of the court, I think that's a very important point, wouldn't necessarily delay it or imperil security if there were pre-clearance and if warrants were granted and then reviewed afterward. In other words, we all know in the ordinary criminal process, some of us have knocked on a judge's door literally in the middle of the night if we thought it was necessary to get a warrant. And the same principle applies here, does it not?
Yes, that's very important. So Senator Feinstein and Senator Graham rightly draw attention to the immediacy of certain threats, the fact that something's coming in a way where you need information fast, and as you say, it's consistent with our traditions to accommodate emergency situations.
And in the short time I have remaining, perhaps I could ask you to elaborate a little bit on the reasons why you recommended a change in the method of selection, which I agree is very, very important to the trust and confidence in this process. And I think one of the reasons for reforming the whole system is to preserve and enhance trust and confidence of the American people, that we are doing both forms of security here, national security and personal privacy.
Yes, I think it was Justice Frankfurter, I may have the reference wrong, who emphasized both the importance of doing justice and the appearance that justice is done, and that is connected with your point. We also think, particularly in the context of the selection of the judges for the FISA court, a little diversity is a good idea across Democratic and Republican appointees. And as the report makes clear, we have all the respect in the world for the Chief Justice and have nothing critical critical to say about him in this connection, but it just is the case that if 10 or 11 come from one political party in terms of the appointing president, that's awkward. And so we'd like to see some more diversity.
And again, it's in accord with the traditions of our judicial system that appearance and perception has to be served because of the immense and, in many respects, undemocratic powers that courts exert. Undemocratic because we believe in elections generally, and here we have unelected FISA court members operating in secret, or other members of the judiciary operate in the open, but they too are unelected. And so I think that your point is very, very important. And I, again, thank you all for your service to our nation. Thank you.
Thank you very much, Senator Blumenthal. The chairman of this committee has asked that we recess for 5 minutes, and so without objection, we will recess for 5 minutes.
not to the swift. First of all, I really appreciate all of you coming here, and I appreciate your willingness to serve on the President's Review Group. The work that you've done has been very helpful, and I'm confident that it will do a lot to frame this important discussion as we move forward. The importance of these issues can't be overstated. One of the things that I liked that you pointed out in your report appears on page 15, wherein you pointed out an interesting coincidence, you might call it, my word, not yours. The concept of security has dual meaning. On the one hand, it refers to the fact that one of the most important, fundamental, sacred obligations of government is to keep the people safe, to protect us from each other, and to protect us from those outside of our country who would harm us. Security is one of the most important functions that the federal government has. And at the very same time, it refers to something different. It refers to something else that might appear to be in conflict with, to create tension with that first concept. And that is the concept of security referred to in the Fourth Amendment, that we have the right under the Fourth Amendment to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures. Now, this concept of what that means to be secure in this second respect has, of course, changed over time. It has necessarily changed as our technology has changed. But the fundamental principles underlying that concept of security must necessarily remain the same. In order for us to remain a free society, and in order for our constitutional protections to continue to be meaningful. One of the things that we have struggled with as a Congress, and that we struggle with really as a country as a whole, relates to the fact that where we keep our papers and what our papers are has changed, especially in the last few years. No longer do our papers consist exclusively of actual paper. What the founding generation would have thought of as papers often exist only in the ether, exist only in the electronic equivalents of ones and zeros. And those are not any longer stored exclusively on hard drives with a finite location that might be in our home. A lot of the time they exist only in a cloud somewhere. And yet these pieces of information, these papers or effects or whatever you want to call them, in many instances are things in which we have, or at least reasonably should have, an expectation of privacy that is reasonable, to say the very least. And so we have to figure out how best to balance these two sometimes conflicting interests associated with security. There are several ways in which this arises, but we've talked a little bit today about the collection of metadata and the fact that we've got an enormous amount of metadata that's been collected on, potentially 300 million Americans. The government notes that it has in place a rigorous review process that must be followed before anyone accesses this database containing metadata on basically every American. What concerns me about that is the fact that these are basically internal operating procedures. And so what is a policy today, which may well be followed religiously for all I know today, could change tomorrow. And I'm willing to assume for purposes of this discussion that the men and women who work at the NSA have nothing but our best interests at heart. I'm willing to assume that, at least for purposes of this discussion. That might not be the case a year from now, or 4 years from now, or 10 years from now, or 40 years from now. In fact, we've seen this movie before. We know how it ends. We know that eventually, if that much information remains in the hands of government for that long, it will eventually be abused. It will be manipulated for partisan and otherwise nefarious purposes, and we can't let that happen. So let's start with Professor Stone. When we look at this, Would this be something that you would describe as one of the most compelling arguments in favor of putting more robust restrictions in law so that they're not simply in the hands of people, however well-intentioned they might be, within the NSA?
Yes, I think this is our primary concern with respect to the collection of metadata, is not the actual use of the metadata in the ways in which it's authorized, but the risk that somewhere down the road, someone will figure out how to and want to misuse that data. And so we think safeguards are critical. I should also say, I think the safeguards that are now in place internally are actually quite good. And they're rigorous, they're multifaceted, there's checks and balances, there's the Senate and House Intelligence Committees, there's Inspectors General, there's Attorney General, the FISA Court, all are looking over this. But even so, our judgment is that it should be taken out of the hands of the government in terms of the holding of the data. And that reduces, doesn't eliminate entirely, but reduces substantially, we think, the potential for the data to be abused in the ways that you're talking about. And it's still a question of trade-offs, because even there's always a risk. But our judgment is that's an important step towards reducing the risk on one side, while at the same time preserving the value of the data for national security purposes.
I think that's right, and for that reason, Chairman Leahy and I and several of my other colleagues across the aisle have introduced legislation that try to reform this process in one form or another. If I can ask one follow-up on this, additional follow-up on this, Mr. Chairman. Some have suggested that it would simply be infeasible, categorically infeasible, ever to require a court order as a condition precedent for performing a query of the government database. And let's assume, for purposes of this discussion, that the data set will remain, at least does remain for the time being, in the possession of the government, and that we're not going to move to a different system in which the government doesn't have possession. The argument frequently arises, you can't possibly require any kind of a court order as a condition precedent for querying that database, even where you've got U.S. citizens involved in the query, because it would just take too much time. Do you know of any reason why that should necessarily be the case, or why that would unavoidably be the case, why we couldn't get around that by perhaps creating additional FISA court positions?
I mean, we find that wholly unconvincing. I mean, our view is that there are practical realities about it. If you're going to add the burdens to the FISA court, you've got to add resources, you've got to add judges or magistrate judges if necessary, but that there's no reason why the argument about getting a court order for a query of the metadata is any more impossible than it is to get a search warrant to search a home. Fundamentally, this is what we do all the time, and there are great protections in having judges oversee this, and there's no good reason why this should not be adopted in this context as well.
Thank you. Thank you, Professor. Thank you, Chairman.
And Senator Franken.
Thank you.
Thank you, Senator Lee.
Thank you, Mr. Chairman, and thank you, gentlemen, for this report. I think it'll be a real help as we work to improve our privacy and surveillance laws. On page 124 of your report, you wrote, quote, "A free people can govern themselves only if they have access to the information that they need to make wise judgments about public policy." I couldn't agree with you more, and right now the American people don't have the information that they need to make up their own minds about these programs. I have a bipartisan bill that would fix this, the Surveillance Transparency Act of 2013, that has the support of 14 of my colleagues and the strong support of the business community, which has broadly endorsed the principle of transparency and has endorsed my bill specifically. When we met last year, late last year, when I submitted written comments to your group, I urged you to support the reforms in my bill, and I'm pleased that your report endorses the same measures that are at the core of my bill. I'm going to focus my questions on the transparency reforms that we agree on. First, my question is on government transparency. 7 months after the Snowden leaks, the government has yet to publicly disclose even a rough estimate of how many people have had their information collected in the telephone metadata or PRISM programs. This is an accident. Under current law, the American government doesn't have to do this. My bill would force the government to annually disclose an estimate of the number of people who have had their information collected by the NSA under each key surveillance authority. Your report supports this. You say that for each for key surveillance authorities, quote, the government should, to the greatest extent possible, report publicly on the total number of requests made and the number of individuals whose records have been requested. Why did you support this particular transparency reform? Mr. Sunstein, why don't you begin, and whoever else wants to.
Well, a theme of our report consistent with your bill is that sunlight is the best of disinfectants, as Justice Brandeis said, and that it's very important for the American people, unless there's a very strong national security justification on the other side, to get a sense of what their government is doing. So the first and foremost goal is about democratic self-government in a free society. That's one of the things that distinguishes our nation from some others. And another idea to which you also referred has to do with economic interests, which shouldn't be trivialized, that there are American companies who are at economic risk because it's thought that the American government is forcing them to turn over all sorts of stuff. It's just not true. Sunlight shows that the program is much narrower and targeted than some people fear.
Well, my bill does that. I want to talk about that next, but any other comments on that? I'm going to just continue to drill down on this first recommendation because it's different from what the administration has been saying and is saying. Your report calls for the government to say how many people have had their information collected. My bill calls for the government to say how many people have had their information collected. Yet last November, representatives from the Office of the Director of National Intelligence and the NSA came before the Subcommittee on Privacy, Technology, and the Law, which I chair, and testified that it would be, quote, difficult if not impossible for the government to say how many people have had their information collected under these authorities. Mr. Swire, did the administration communicate this concern to you? If so, why did you find it unpersuasive?
Thank you, Senator. We talked in some detail with the administration about transparency provisions. They certainly expressed concern at when there's a provider that has a very small number of customers, for instance, that we not tip off people who's being surveilled in those cases. There's a national security problem there. I think when it comes to the number of people who've been touched by the orders, they did not focus in their discussions with us on that risk and transparency. And my own sense, having talked, among others, with the companies on this, is that if there's cooperative efforts to have the companies, the providers, work with the government, that we're likely to be able to come up with practices that allow estimates. You might not have exact numbers in all cases because sometimes you don't know if the same email applies to 3 people or 1 person. So with precision, you might not have exact details, but I think you can have good trend numbers and you can have a good overall sense of what's happening.
Okay, so, well, I'm out of my time, and as you can see, we're having another vote. So we will recess for 5 minutes for another vote. Before we do, I just want to, Mr. Sunstein, just reiterate this thing about the companies, their ability to disclose, because it is hurting them. And we had an analytics firm, Forrester, so the American cloud computing industry stands to lose up to $180 billion by 2016 as a result of increased distrust of their services, particularly abroad. So thank you for that being being part of your recommendation. So we will recess for 5 minutes because I've got to go vote, and I better go right now. So we're recessed. Oh, Senator Cruz. Oh, good. I'm sorry. I guess I'm the chair. I call on Senator Cruz.
Thank you, Senator Franken. And I want to begin by just thanking each of the members of the panel, thanking you for your service in the intelligence community, and thank you for your service looking at the difficult and important legal issues and privacy issues that surround this critical area. I think a great many Americans have concerns about the current state of NSA surveillance. I, for one, have concerns on two different fronts. I am concerned, on the one hand, that the federal government has not been effective enough monitoring and surveilling bad guys, that we have not succeeded in preventing what should have been preventable terrorist attacks. And at the same time, I'm concerned that the sweep of the surveillance has been far too broad with respect to law-abiding citizens. And I think a great many Americans would prefer to see that reversed. Far greater scrutiny on bad guys, people that we have reason to suspect may be planning a terrorist attack, and far more protection for law-abiding citizens who have committed no transgressions. And so I want to begin on the first piece on targeting bad guys, and I want to follow up with the question Senator Graham asked earlier concerning Major Hassan and his communications with al-Awlaki, a known terrorist leader. Despite all of our surveillance capabilities, despite having significant indications that Major Hassan was engaged in these communications, the federal government failed to prevent the horrific terrorist attack that claimed the life of 14 innocents at Fort Hood. And so the first question I'd like to ask the panel is, in your judgment, why is that? What was lacking that prevented us from acquiring the information and acting on it to prevent that act of terror?
Well, I guess I'd say that it is a very important question, and your general thought that to target through surveillance known bad guys, that is something that we did devote a great deal of attention to, and recommendation 15 is of, I'd say, of great importance. It's gotten essentially no attention so far as I can tell, not even on Twitter has it gotten attention. And that recommendation is that we need to expand our authority to track known targets of counterterrorism when they first enter the United States. So that's a gap in our statutory structure, that when they come to the United States, they get protections immediately, so we can't track them. Whether that would apply to, in any way to the case you're describing, I don't think so, but it is an important gap. That one, I think, probably as a group, we'd need to get more into the details than we did.
Mm-hmm. Mr. Burrell, I would welcome your thoughts also on how we could have done better preventing that terrorist attack.
Senator, it's not something that we as a group looked at. That wasn't our mandate. I am familiar with the case, obviously. I'm a little constrained here because I don't know what's in the unclassified world and what's in the classified world. So maybe we could have a conversation afterward in closed session.
Okay. A follow-up question for the panel, if anyone would care to comment. The same is true with respect to the Tsarnaev brothers, the Boston bombers, where in that instance we had intelligence from Russia that they were having communications with radical Islamic groups, and yet for whatever reason, their radicalization continued, the government dropped the ball, and they carried out yet another horrific terrorist attack. Do members of the panel have any views as to why our surveillance capability did not provide sufficient information to act upon to prevent that terrorist attack before it occurred?
So, Senator, I'll tell you, in that case, there weren't any communications between the United States and overseas. So there was no surveillance of those communications that would have provided any information that would have prevented the Boston bombings. And this is largely a case of domestic radicalization. And I think that's the best way to think about it.
Well, but as I understand it, the elder Tsarnaev brother after traveling to Chechnya, after meeting with radical Islamic groups, came back and posted on public YouTube pages admonitions to jihad. And that certainly doesn't take extraordinary surveillance capability. It simply takes the government looking to what he's saying publicly and loudly before that terrorist attack is carried out.
Yeah, and I was making a different point, Senator. You're absolutely right, but I was making a different point about actual communications and the collection of those communications.
Well, and I think that underscores that my concern that the focus of the programs has been far too much on law-abiding citizens and far too little on people for whom we have significant reason to believe there may be a real danger of terrorism. And with respect to Major Hassan, with respect to the Zarnoff brothers, I'm not sure there could have been too much surveillance based on the information we had to protect national security. Now, flipping to citizens at large, am I understanding correctly the conclusions that the Commission received, that in your judgment, the bulk metadata program has not to date prevented any specific terrorist attack? Is that an accurate understanding?
Yes, that's a fair understanding. We think that it's contributed some useful information, but could not say that any particular terrorist attack has been prevented because of the information learned from the metadata program.
Now, an additional recommendation, as I understand it from the Commission, is that the government itself stop collecting metadata, but that private companies, the phone companies that already have that data, preserve that data, and that searches be conducted only when there is specific cause to search, rather than, in a blanket sense, the government sweeping in every law-abiding citizen.
Precisely.
And is it the judgment of the Commission that if the data were kept in private hands of the phone companies that already possess the data legally, that would do nothing to undermine the efficacy of the program preventing potentially future attacks?
We believe that that way of handling the data can be done in a way that would not in any way undermine the efficacy of the program. On the other hand, we recognize in our report that that's speculative. We don't know that for a fact. And if, in fact, it turns out that there are inefficiencies that make it more difficult to use the data in an appropriate way, that the alternative is to have it held by a single private holder. And that would basically eliminate most of the inefficiencies.
Focusing also on the question of potentially overbroad surveillance. A couple of weeks ago, Senator Sanders wrote a letter to the NSA asking if the NSA, quote, has spied or is the NSA currently spying on members of Congress or other American elected officials. And the NSA's response to that was members of Congress have the same privacy protections as all U.S. persons, which certainly suggests the answer to that question is in the affirmative. Now, as I understand it, each of you were granted security clearances and the ability to see classified information in court opinions. And so the question I would ask this panel is, are you aware, has the NSA ever done surveillance on members of Congress or other elected American officials?
We are not aware of any such. And one of the things we learned in our review is that there's no targeting by the NSA of people because of their political views or their religious convictions or their political party. So in terms of concretely some details, we may not have precise questions that every one of which we have off the top of the mind answers to, but politics, religion, political views, that's not what they're interested in.
Just one small thing. We're talking about in recent years. We're not talking about back in the 60s and 70s when there's a different history about intelligence agencies doing things that got exposed.
No, I mean in current years. Although I do want to clarify, Professor Sunstein, one thing you said about religious views. I assume you would agree that a commitment to jihad would not qualify as a religious view and indeed would be a political position and embrace of violence that merits very close scrutiny to prevent that violence from being
Yes,
carried out.
if there's a reason to believe the person is threatening to the United States, that would not fall within protected religious belief.
A follow-up question related to the question about members of Congress: is any member of the panel aware whether the NSA has spied or is spying on the judiciary, or in particular members of the Supreme Court?
We have no information to that effect and would not anticipate that.
Very good. Well, I want to thank each of you for being here. The remainder of the committee is off voting, and so with that, we'll take a 5-minute recess, and then I expect my colleagues will return, and the hearing will commence again then. Thank you.
I'm almost afraid to ask what the joke is, but those hidden microphones we have under your table are probably to tell us. The surveillance camera. When people are coming back, I just wanted to note a couple quotes from your report. One is the question is not whether granting the government authority makes us incrementally safer, but whether the additional safety is worth the sacrifice in terms of individual privacy, personal liberty, and public trust. It's the public trust, as we know, so many times we have to rely on individuals in the public who might give us information that can be valuable, but they have to have the public trust. I mean, law enforcement knows this, but same with the intelligence community. And I think I'm about to yield to Senator Whitehouse, but Mr. Morrell, in your review, did you identify a difference? And I think you've already answered this in one question, between the demonstrated utility of the government's activities under Section 702 of FISA, which is aimed at non-U.S. persons abroad, and that of the phone records program under Section 215?
Yes, Mr. Chairman. 702 has proven to be much, much more valuable as a counterterrorism tool than has 215.
Thank you very much. Senator Whitehouse.
Thank you, Chairman. Mr. Morrell, how would you characterize the value of the 215 program? From an intelligence perspective, and if you will, from a safety perspective, even if it hasn't generated intelligence, the fact that it might be of some value. And I'm interested in your assessment of its value in both of those dimensions.
Yes, Senator, that's exactly where I am. It is absolutely true that 215 has not by itself disrupted, prevented terrorist attacks in the United States. But that doesn't mean that it's not important going forward. Because as I said in my op-ed, it only needs to be successful once to be invaluable. One of the ways that I think about this is many of us have never suffered a fire in our homes, but we still all have homeowners insurance to protect against that. And that's one of the ways I think about 215.
I've had the concern that the prospect of an unauthorized leak and a sudden, spontaneous, unanticipated disclosure was not foreseen by the intelligence community, and that there did not appear to be a response that was timely, sensible. They didn't seem to be at all prepared. What is your sense of what the reaction was by the Intelligence Committee? Was it really as much of a scramble as it looked like from the outside?
Senators, I was inside for part of it and outside for part of it. So my sense is that the strategy that was being pursued was not successful, clearly not successful. The strategy that was pursued did not mitigate the lack of public trust, did not win back any of the public trust. It was absolutely clear to me that, and this picks up on something Professor Stone raised earlier, that this was, as you know, one of the most overseen programs in the history of the intelligence community. Within NSA.
In the history of the country.
In the history of the country. Within NSA,
yep.
Within the executive branch and the interagency, within the Justice Department, within the intelligence committees of Congress, and with the Judiciary, which is, as you know, very, very unusual for an intelligence program. And I think that there was a sense in the intelligence agencies and in the executive branch that that level of oversight was enough to keep the public trust if there was a disclosure, and I think that turned out to be wrong.
I wonder if it might have done better if within the first couple of weeks, frankly, a full disclosure of how the program had been carefully overseen came out. Because it took, it seemed to me, days initially and really weeks until there was a solid, comprehensive review. In fact, what you've just said is one of the clearer expositions that we've heard yet. I think this is one of those cases where, you know, a not completely accurate image got across town before the truth got its boots on. And this is going to happen again. I mean, we live in a society in which there are going to be leaks, and I think for the intelligence community not to be prepared for this is a mistake, and in particular it's a mistake because there was no analysis of if it all happens at once and we make a hash of responding to it, what happens to this program. You dial back from that, if that's the way you're thinking, to being more candid up front and diminishing that risk. And I think we could have been a lot more candid with the American people up front about this program without creating any significant national security loss. So anyway, that's my thought. My time is running out. I just want to take a moment and thank you for your service to our country. In my time on the Intelligence Committee, I found you always extremely capable and honorable. And I want to also thank Mr. Clark here, who has warned of many things that if we and others had listened more carefully, we could have avoided some real disasters. So I'm very pleased that both of you are here today and want to thank you.
As chairman of this committee, I would join with that. What we're going to do, I'm going to yield to Senator Sessions, who has been running back and forth with me to votes. I'm going to ask Senator Blumenthal, senior senator from Connecticut, to take the chair. Then we'll recognize Senator Coons and Senator Klobuchar. But before I leave, in the indulgence of members, I've spent decades on this committee. We've had some terrific panels. I can't think of anybody that brings the wealth and broadness of knowledge to an issue that the five of you do. And I say that just because you've given a great deal of your time in public service, a great deal of your time in doing this. And it's extremely valuable. Whatever we do is going to be influenced heavily by your report. And I appreciate that. I know the president also appreciates the amount of time you've done. With some of you, I go back longer, as I have with Mr. Clark, but Mr. Morrell, in your days, especially as acting director of the CIA, the clearness of the briefings you gave to several of us here. It's unfortunate they're all closed doors, so the public didn't see what they were, but they were extraordinarily helpful, and that was something heard from both Republicans and Democrats, and I appreciate that. And of course, Professor Sunstein and I have known each other for a long, long time, and he's been extremely helpful to this committee. And Professor Stone, Professor Swire, thank you so much for the time you've taken. So I'm going to turn it over to Senator Blumenthal and yield to Senator Sessions.
Thank you. Well, I know Senator Leahy has spent a number of years dealing with these issues also, and I believe the Patriot Act that he helped craft and we all worked on and spent hours and hours and hours on was not one of these things where you have to reduce constitutional rights in order to protect America. I think that was the wrong characterization of it. I believe everything in that bill was consistent with then existing criminal law techniques that were used every day by prosecutors in the counties about America, in U.S. attorneys' offices, which I was for almost 15 years. And I don't believe that there's anything there that we should be apologizing for. So the committee is an excellent committee and a highly intelligent committee, but I would note that 3 of the members are never had hands-on experience with this. You've written about it, but you haven't been in the field directly dealing with these issues. And I think anyone would say It's a pro-civil libertarian panel. Therefore, I am rather pleased that you fundamentally, I think, agreed with at least some of what I've said. You say, although recent disclosures and commentary have created the impression in some quarters that NSA surveillance is indiscriminate and pervasive across the globe, that is not the case. NSA focuses on collecting foreign intelligence information that is relevant to protecting the national security of the United States and its allies. And I think that, I know you didn't say that lightly. I know you wouldn't have said that if you didn't believe it. You go on to say the group found no evidence of the illegality or other abuse of authority for the purpose of targeting domestic political activity, close quote. I think that's good to hear, and has always been my impression. And also you say, in our review, we have not uncovered any official efforts to suppress dissent or in any intent to intrude into people's private lives without legal justification. NSA is interested in protecting the national security, not in personal details unrelated to that concern, close quote. Of the 300 and something million American people, they're not interested in what all we're saying on our telephone calls. So I think that's important. I thank you for that. And I believe those who have raised concerns about it could take some comfort into that. You know, I was a prosecutor, as I said, for a long time, and I want to raise the question about the metadata. That sounds so awful and scary that makes us nervous, but in conventional prosecutions in America today, a county prosecutor who's interested in knowing who a criminal suspect is talking to issues a subpoena to the phone company, and they submit the records to him. And then he examines the records to see if bad guy 1 is talking to bad guy 2 shortly before the robbery took place or whatever. This is the kind of thing that's done every day in every office. The DEA, the IRS can issue record, obtain your motel records, your telephone records. The IRS can get every bank record you have administratively. They don't even have to issue a grand jury subpoena for it. And examine somebody's financial records. Now, the reason is these are not their records. They're not the individual who's being investigated's records. They're the phone company's records, the bank records, the hotel's records, right? I mean, that's the difference. You have a diminished expectation of privacy. The Supreme Court has clearly held for the last 100 years, I suppose, in records not held by you. Okay, so the records now, though, are brought to the United States somehow. They're in our custody because of the way the computer systems work, and we get numbers, basically. So, Mr. Morrell, I guess you've used the system. Would you share with us, is there any difference between the traditional issuing of subpoenas for records and the way this is done, and what the importance or lack of it of the government getting the records from the companies in bulk and then accessing them? And do you, finally, to what extent is content obtained, the actual conversations?
Yes, Senator, I am not the best person to answer that question, so let me defer to my colleagues.
Okay. Who would like that? Mr. Stone? Now, Mr. Stone, I'm glad to hear your comment, but you're on the board at ACLU, I believe. Is that right?
National Advisory Board, yes.
Yeah, and did you support the ACLU lawsuit against the government raising many issues concerning this?
I had nothing whatever to do with that at all.
So you don't feel any conflict
no.
in serving on this commission? Okay.
Not in this
Go ahead and see if you could be glad to hear your answer.
I think what's changed is the nature of the technology. And so when you talk about subpoenas, whether it's through a grand jury or an administrative subpoena, typically looking for a very focused type of information relevant to a particular investigation, narrowly defined. When you're comparing this to the metadata, you're talking about millions of Americans' records swept up. No subpoena.
No, wait a minute. Swept up.
No
They're in this somewhere in a computer.
No subpoena has ever been allowed to reach that breadth that happens under the metadata program. So I think that the analogy is simply a flawed analogy.
And looking at every record that's there, they have to have some sort of indicia that is valid or valuable for an investigation to even inquire into it.
Yes, but you were drawing an analogy to the subpoena. And what I'm saying is that the subpoena traditionally has to be relatively narrowly drawn to particular information directly relevant to a particular inquiry. And the metadata program does, in fact, elicit vast amounts of data, far beyond anything that any subpoena in the history of the world has been allowed to gather.
Okay, let's get this straight. So the metadata comes in, and the only difference is it was in the computers of the phone company, but for easier access, it's put in the computer of the government somewhere, and the inquiries only go to those records just like they would have gone to the phone company. The only difference is for convenience and computer access, it was government can get it quicker, and because some of these issues are life and death.
As the Supreme Court, 5 justices at least of the Supreme Court have explicitly recognized a year ago, there are limits that technology now has called into play about how far this doctrine that if you disclose information to somebody else that you have no reasonable expectation of privacy in the information. So in the Jones case, 5 justices, including Justice Alito, in a very important opinion, suggested that that basic principle that, as you say, was around for a long time, has to be called into question when you get into a world where technology allows...
that to this date, have they?
Excuse me?
Say they called into question. No holding.
No.
Has been so held.
No, and indeed nothing we say has anything to do with the constitutional
hold that. I don't see any difference, really. You're accessing the same records, whether you get them from the phone company or whether they're in bulk in the more accessible account.
So if this is helpful, I think the direction you're going in is actually quite compatible with our recommendation. So our recommendation is not that we eliminate the 215 program, but that we have a program where the government doesn't have all this stuff, which the government doesn't in the cases you worked on as a prosecutor or district attorney. It doesn't just have it, it gets access to it on a certain showing. And that's exactly the model that we're suggesting. And what we suggest is that that model won't compromise any national security goal, because in cases where time is of the essence, human life is on the line, you can get at it like that. And because in cases where it isn't on the line, you go through the standard legal process. So the analogy from tradition to which you rightly refer, that is actually what we're building on in our recommendation.
My time is up. Thank you. General McCasey, former Attorney General McCasey, federal judge for 20 years, does not agree. He thinks that will impact adversely the mechanism of the system in a recent op-ed. Thank you.
Thank you, Senator Sessions. Senator Coons.
Thank you, Senator Blumenthal, and I'd like to thank the entire panel for your service to our nation, for your testimony here today, and for your hard work to make sure that we really focus on and get right some of these tough questions. Just to follow up on the exchange that just happened, if you might, Professor Swire, how did the review group's suggestions surrounding the Section 215 authority address the constitutional concerns that were raised by Judge Leon? If you could just focus us on the outcomes.
Thank you, Senator. Our task that we were asked to do was not focused on constitutional analysis. Our task was on what policy should be going forward. So as a group, we did not try to make an assessment on the constitutional issue.
But in your view, do the group's recommendations actually address some of those concerns or fail to address them?
Well, we tried to do the task we were assigned. I think that, as Professor Stone was just saying, there's discussion in the report about how metadata looks given changing technology. And so in the 1970s, there were a limited number of phone calls. Today, the number of texts and Facebook posts and everything is enormously different. And that kind of difference is the kind of difference that 5 justices of the Supreme Court referred to in the Jones case. So we asked for a study, among other things, on these metadata issues because we think that the changing facts require some changing law probably, but we don't say on the Constitution what our view is.
Mr. Morrell, if I might, the review group recommends replacing the Privacy and Civil Liberties Oversight Board with a new Civil Liberties Protection Board. And this new board would be empowered to review the privacy implications of all counterterrorism and foreign intelligence collections and have a new function to respond to whistleblowers and have new investigatory roles. The current PCLOB is, I would suggest, absurdly under-resourced relative to its scope of responsibility. The President's budget request includes only, I think it was $3.1 million for the PCLOB. I may be wrong on that. Authorities without resources can be worse than no authorities at all because they provide a false sense of security. I would be interested in your view of what budget would be sufficient to allow this new board to perform its mission.
So I don't have a specific answer for you. That's not something we looked at, but it would be significantly more resources, in my view, than it currently receives today.
Well, the Intelligence Community Inspector General, just to continue the examination, ostensibly exists within the IC to ensure legal compliance. And it recently told us that it lacks the resources to conduct a thorough and full review of the 215 metadata program by the end of next year. So I think that reinforces the point that some significant increase in resources is needed to ensure the sort of oversight and accountability that I think all of us are working together to ensure. Mr. Clark, if I might, declassified FISC opinions have revealed that the NSA in the past exceeded court-established bounds of the Section 215 bulk metadata collection program routinely and attempted to defend those actions in front of the court. I think it's widely now agreed that this was a violation. Some of us would allege a serious one. My concern is that the NSA initially tried to defend its use of non-approved selectors, and I'd be interested in your view about why the NSA attempted to defend its illegal actions as legal and what reforms are necessary to encourage the IC to come clean and admit its mistakes in cases like this.
Senator, I think there was a good faith lack of understanding and lack of communication between NSA and the court. I don't think there was any intentional attempt to circumvent the court, but I think we had a bunch of engineers and computer scientists at NSA talking to a bunch of lawyers at the court, and I think there was a lack of understanding about what each side was saying. I believe as soon as the NSA learned of the court's objections, they rectified the problem. So I think what this points to, these incidents point to, is the need for the court to have more technical staff and resources. Just as the P-Club, as you mentioned, is grossly under-resourced, so is the court.
Are there any other elements of your recommendations that would deal with this cultural mismatch, at least as you suggested, you've got engineers and lawyers? Anything about adding an advocate to adding a more adversarial component to the deliberative process? Would that also strengthen the court's capabilities and oversight?
I think there are 4 or 5 recommendations to do that. One is a public advocate in the court. Another is strengthening the technical ability of the court staff. A third is creating in the new Civil Liberties Commission a technology assessment staff.
The review, if I might, Mr. Clark, my last question, looks at 2 authorities, Section 702 and Section 215. And these are both sections about which there's been a lot of public debate and discussion. But the review group also recommends greater government disclosure about these and other surveillance authorities it possesses. But the report appropriately and understandably does not itself disclose any additional programs. What review, if any, did the group make of undisclosed programs? Or could you at least comment about whether lessons learned from such review is in fact reflected in the report?
Well, I think there's a great deal of metadata collected by the National Security Letter Program, and we do speak to that in the recommendations. There's also a great deal of communications related information collected under the Executive Order 12333. Public attention is focused on 215, but 215 produces a small percentage of the overall data that's collected.
Thank you. Thank you to the whole panel for your testimony. I see I'm past my time.
Senator Klobuchar.
Thank you, Mr. Chairman. I first want to note for the record that 2 of the witnesses were my law professors. Professor Stone taught evidence, and Professor Sunstein was my administrative law professor, and they both were fans of the Socratic method, so this is my revenge. Okay, so I first wanted to start with some of the recommendations here, and one of the most prominent recommendations of the review group was the U.S. government should no longer hold the metadata, but data should be held by either the companies or a third party. I remember that General Alexander said he was open to this idea back in July, and I guess starting with you, Mr. Clark, do you think that this would lead to greater security, or do you think there could be more of a possibility of it being hacked? And then I guess I'd ask the professors if do you think they would then, the companies will be insisting on protections for liability?
Well, Senator, thankfully I was not your professor. I note that there's been a very significant information compromise at NSA, well over 1 million documents stolen. So even NSA can have its information stolen. It's not just Target and other commercial entities.
Thank you for bringing up my hometown company.
Sorry about that.
That's all right.
I'm unaware of people's phone records going into the public record when they were stolen from phone companies. They're there now. We're not suggesting something new. The phone companies have the data. We're really suggesting that they keep it rather than the government. If rather than leave them at the phone companies, we went a third-party route, yes, you're absolutely right. The security of those records would have to be paramount, and I believe that security can be achieved from hackers. We spend a whole chapter in the report talking about how to do that. It's just that most people don't do it.
Okay. How about the liability issue?
Liability, I think, is a matter of your providing safe harbor by legislation.
Agreed. Okay. One other recommendation was to create, which has I know been discussed before I got here, was the public interest advocate at the court to provide for a more adversarial process, to provide for someone to ensure that privacy and civil liberty interests were represented. Approximately what proportion of the cases should be substantively argued by a public interest advocate on privacy and liberty grounds? Do you see it as happening in every case, or a percentage of the cases?
The reason I say approximately small is that the overwhelming majority of the cases don't involve novel or difficult issues of law and policy. So one thing we're focused on is the possibility that the public interest advocate wouldn't have as many hours of engagement as a standard lawyer does, just because a lot of the cases are routine. We don't have an exact percentage, but where the issues of law or policy are novel, then there is a keen importance to making sure it's an adversary proceeding.
Yeah, I thought this was a good recommendation. Yesterday, the committee did receive a letter from Judge Bates, the director of the Administrative Office of the U.S. Courts, and a former presiding judge on FISC, in which he raised some significant questions about proposed reforms, including adding a standing special advocate to the court, and recommended instead that the court be allowed to appoint an advocate on a case-by-case basis. Does this make sense to you? I don't know if you want to...
We admire Judge Bates and respect his views. We respectfully disagree with that one on the ground that the judge sometimes is not in the ideal position to know whether a particular view needs representation, and that in our tradition, standardly, the judge doesn't decide whether one or another view gets a lawyer. And this is an unusual context, admittedly, but if there's a privacy or civil liberties concern, it's good to have someone who is specially authorized to take account of that concern in deciding whether to participate.
Makes sense. The public revelation of the surveillance programs, particularly those targeting foreign leaders, has generated a strong outcry from some of our allies, including Germany and Brazil. And the review group recommended that the U.S. intelligence community limit surveillance focused on foreign leaders to instances where there is a clear need, and that such intelligence requirements be subject to senior policy maker review. I guess, first of all, I'd ask, I think Mr. Morell, would this be your area? In your view, did the surveillance of Prime Minister Merkel meet the standards that you're suggesting here?
Ma'am, I can't confirm or deny the surveillance of any particular foreign leader. I would say that I think it is absolutely important that policymakers make decisions about collection at that level, and that has not been the case heretofore.
And the review group also recommended extending the protections of the Privacy Act of 1974 to foreign citizens. Is there a precedent for the U.S. government or any other government to extend privacy protections to foreign citizens in its conduct of intelligence collection?
Thank you, Senator. On the Privacy Act, the Department of Homeland Security for several years has had a policy that we say should be adopted more broadly, which is when there's a mixed system of records and there's U.S. and non-U.S. people in that, then the non-U.S. people would have access to those records as well. So we're building on the precedent from Homeland Security.
Okay, very good. Anyone want to add anything more? All right, thank you.
Thank you, Senator Klobuchar. Senator Durbin.
Thanks, Senator Blumenthal, and thank you all. I regret that Osama bin Laden brings us to the airport about an hour earlier than we used to go, and I regret that Edward Snowden brings us together today, but I think we have to acknowledge the obvious. There's a public question now about privacy and whether the government is going too far. It's a question many of us contemplated in the past but could never discuss openly. Now that this is a matter of public record, we have this hearing, as we should, to try to restore the confidence of the American people. Several of you are authors, and I've read your works on a lot of different issues, but the issue before us today is one where the word is not even found in the Constitution, privacy, and what we can come to expect and what the court might view as going too far, any court might view as going too far, and whether the court of public opinion would view as going too far. When you consider the incredible advancement in telephone technology, smart mobile phones, the ubiquitous use of the internet, is it time to revisit whether Smith versus Maryland is in line with the expectations of the American people about privacy? In a world that we live in where phone booths are viewed as some quaint anachronism, and people stand up in the middle of a crowded plane and broadcast their telephone conversations to everybody within earshot, where we know that commercial invasion of our personal privacy is taking place almost constantly, and the accumulation of information by our government is only a fraction of what the commercial sector is gathering about us every single day and every move we make. Take a step back and get to altitude here and tell me what you think the issue of privacy looks like.
Well, Senator, from a 100,000-foot level, we do believe that in the current technological environment, if people use the internet or the telephone or banks, it is right, certainly as a matter of public policy, to protect their privacy and to focus on striking the right balance between national security needs and the needs of government to get access to information that can protect us against those who would do us harm. So we were not asked to investigate the constitutional issue as if we were judges, but we were alert to your concerns very much so in offering our recommendations.
And is it not a fact that if I could obtain anyone's phone logs of the actual phone numbers they called and know the names of the persons they called, I could probably draw some inference about them, their lives, maybe their intentions?
Unquestionably. So metadata is not the same as content, but it is something that people are understandably skeptical of the idea that others get access to, especially the government, for exactly the reason you give.
And if we let the telephone companies retain possession, pardon me, of this data and go after it as needed, what kind of obstacle does that create in going after bad guys, Boston bombers, where we might come up with a telephone number and need to know pretty quickly whether this is isolated or part of an international effort?
If there's a need, either because something bad has happened in the recent past or because there's reasonable grounds to believe it's going to happen in the near or pretty near future, then if time is of the essence, there's no need to go to court. So we would design our recommendation and the legislation that would respond to the recommendation in a way that acknowledges that sometimes you have to move very fast.
Senator Coons raised this question, I'm sure it's been raised earlier before I came, about adding some balance to the FISA court so that there is at least something akin to an adversarial proceeding, or at least both sides of the issue are being heard. What do you feel, based on the work that you've done, is the most credible way to establish that?
Thanks, Senator. I'll just say a couple of things that are in our report. One thing is that trying to think about who those people are institutionally is something that I think deserves some public attention. The people who would be advocates would have to have a clearance because they'd have to be working in the FISA court. You'd want them to have some continuity over time so that the last case is known to them enough so that the next case makes sense. And it might not be a full-time job because it's only occasionally that the big minimization cases happen.
Who would they work for?
Well, and so we suggest some ideas that hadn't been as much discussed in the public before that. One idea would be to put it at the P Club, the privacy board, or whatever you call it going forward, because they have a lot of other jobs to do and they have lawyers. Another possibility is to put it out for bid so that some law firm or public interest group would have 3 or 5 years where they're doing it. They have a day job, but when it's important to do it, they're there to do it. The concern is if you just sort of pop in and out, you wouldn't have the technological and other context to do it well. And if you sit there full time, you have nothing to do for weeks at a time, possibly.
We have this quaint concept of an inspector general in departments, working at the department but not for the department, literally charged with taking a look from an outside point of view, and most of them emerge with some credibility because of this relationship. Is that something that we could build on?
Historically, my understanding is the IGs haven't had a legal function. That putting a legal office in the IG would be, you're saying but my understanding is that they've had fraud, waste, and abuse, but not being the best lawyers you can get. If you want the best lawyers you can get for privacy and civil liberties, arguing with the court and with the very great justices, lawyers in the Department of Justice, thinking about how to staff that so you'll have really good people available, and they probably need something else to do the days of the week when they're not doing this because there's not that many cases.
I might just close by saying 2 things. First, the pending appropriations bill, the omnibus bill, contains some provisions which I've added that will finally make public as much as can be made public, a lot of specific data about what has been collected and why it's been collected and what the results of the collections has been. It's been an issue that's been important to me for a long time, and it's going to be part of the bipartisan bill. And finally, I support what Senator Blumenthal is trying to do to make sure these FISA courts are more balanced in the appointees. Not to take anything away from the current process, but I think if there were more diversity in the selection, there'd be more confidence in the outcome. And I think his legislation is a good move. Thank you.
Thank you, Senator Durbin. Just to pursue Senator Durbin's point about how to house the special advocate or constitutional advocate or public advocate, I think the key question that he asked is, who does she or he work for? Who's the client? And my concept in advancing it originally was always that the client is the individual or group whose constitutional rights may be imperiled. In other words, it really is the Constitution. And the appearance, again, we talked earlier about appearance and perception being important. Housing is important from a perception standpoint. If the public defenders in federal courts, and I dealt with a lot of them as a U.S. attorney, were housed in the prosecutor's office, clients coming to be defended would have a totally different perception, even though it might actually save money to put them in the prosecutor's office. So I think there is a very important analogy here, and that in the federal system, we have federal public defenders who are full-time. They're not ad hoc, although for a long time, people were represented by, and still are in state courts, by people sort of hauled into the process to do their duty with minimal pay while juggling other duties, and sometimes not clear that they had the experience to handle a particular case. And that's why I have advocated a full-time, institutionalized, separate office that is independent as possible, because perception is so important. And I want to thank you all for giving thought to the excellent kind of questions that Senator Durbin and Senator Clunes and Klobuchar have raised. One last point, again, to pursue Senator Durbin's question. Smith v. Maryland is about as outdated as I think any Supreme Court could possibly be, given that it was dealing with a different system of information gathering at a different time, not only with payphones, but literally the wires, the mechanism, the infrastructure was so different. And I think the elephant in the room here is really the Supreme Court. Many of our colleagues have said, well, we ought to wait for the Supreme Court. but we all know that the Supreme Court isn't necessarily an absolutely clear and non-controversial source of law, and we have an equal responsibility. The Congress, under the United States Constitution, has an equal responsibility to protect the Constitution, indeed to define the Constitution. And that's why your work, I think, has been very, very important, because you've really, as I mentioned earlier, not only given us some guidance, but great credibility to the direction that I believe and hope the President will go. So if there are other comments, we're going to hold this record open for 1 week. Senator Sessions has asked me to place in the record a Wall Street Journal opinion article by former Attorney General Mukasey. It's entitled "The Air of Unreality in NSA Reform." And we will hold this record open for a week, and thank you all, gentlemen.